to 21 years of age, and 29% are over 21 years of age. So thank you so much. Let me hide that poll for you. I wanted to share that this is brought to you today by the Special Education Task Force. I know that Jane is a part of that. But their goals are to provide a forum where parents, advocates, schools, personnel, providers can help discuss issues, policies, changes to laws that are impacting students with disabilities, to be purposeful, to choose and conduct all activities in a manner which promotes participation and collaboration of stakeholders, to promote and encourage networking discussions, to identify issues that impact students with disabilities and promote awareness of those issues, and to share information about issues, trends, gaps, initiatives related to students with disabilities with the New York State Special Education Task Force. So we would like to thank them for helping to promote that. In just a moment, I am going to switch this over and we will I will have Yolanda share with us and introduce herself. So Yolanda, if you'd like to go ahead and introduce yourself.
Sure. Hi, everyone. Thank you for being here. My name's Yolanda Asamoah-Wade. I am the attorney for special education at the Rochester City School District, and I'm glad to be here. Welcome.
Great. And Jane, would you like to go ahead and introduce yourself?
Certainly. My name is Jane Gabriele. I am an education attorney, a special education attorney that represents families of students with disabilities. I work for the Empire Justice Center. That is a nonprofit public interest law firm that provides its legal services free of charge to people who are in need of assistance but couldn't otherwise afford that support.
Great. Thank you so much. So we're going to go ahead and get started. Again, I wanted to share with people, please feel free to type your questions in the question pane. And we will try to answer them in the order in which we received them. And if something comes up that pertains to that particular slide that they're talking on, I will bring that up to both Jane and Yolanda. Also, we get to see both of them today, which for me is very exciting because I enjoy listening to both of them. They are extremely knowledgeable. But if for some reason you wanted to move them out of the way, there should be a little dash, or if you click out of that screen, you should be able to just see the slides. So I hope that was helpful. So we're going to get started with our first question. And it says, what obligation does a school district have to deliver instruction during the current school closings?
So in addressing that question, first we wanted to just Yolanda and I wanted to let you know that we're not going to sit here and read you the law. We put the law into this PowerPoint so that you could refer to it. But the point of this exercise is as so many of us have been in settings like CSE meetings or in partial hearings, where in fact, there are attorneys, and their purpose in being there is to represent the different perspectives on the law. So Yolanda and I are taking the questions that were provided to us by our lovely audience. Thanks, you guys. And we've organized them into a PowerPoint that will give you the question and then provide you the law, the reg, the guidance that we're getting right now on that issue. I'll tell you sort of the parent's perspective, and then the parent attorney perspective, and Yolanda will be looking at it more from the district side. So with regard to this question, the districts always have an obligation to provide a free, appropriate public education to their students, regardless of circumstance. That's the legal standard. And we've provided that part of the law. The determining what equals appropriate is very difficult, and as you can see from the legal guidance, it's not a reflection of whether or not the student is advancing through the grades. It's whether or not the progress that they're making is appropriate. We'll talk about that again more in a minute. But what about during this time of craziness? Can you move ahead to the next slide for me? what we got from the special ed people, the big important people, was that if a school district was providing educational services to a regular ed student, then they would have an obligation to provide equal access to students with disabilities during these school closings. That got a little bit crazy because we had a few local districts that perceived that as, okay, then we won't provide any educational services to the regular ed kids because that'll take us off the hook for the students with disabilities. There was an immediate response from the leadership that that was not their intention. And so it's our experience that right now the districts are providing to both the regular ed and special ed students a lot of distance learning. Did you have a perspective on that, Yolanda?
Sure. Yes, this was exactly what transpired. And I think in the beginning of the closure, there was just a tremendous amount of confusion amongst districts. I mean, we're all in the same boat together with this all across the country, and everyone's trying to figure it out. Every one state is giving them guidance. The thing about it is that the law itself hasn't changed, but with respect to a few waiver provisions, the basis of the law hasn't changed, and so the requirements are still need to be met. The way this has evolved now is districts obviously not wanting students to lose as much as they might otherwise stand to lose if nothing was done, and the guidance is clearly saying that something must be done. I think districts would likely take the position that whatever is done for general ed students is what will be done and must be done for special ed students, and that their accommodation supports and specialized services be delivered in conjunction with that to the greatest extent possible under the circumstances. So I agree that this is where we are now, and I think most districts are providing some form of continuity.
And that's a great lead into the next question. Could you advance us to the next?
Before we go there, I know that our slide that also touched on suspension and the provision of FAPE during suspension. Generally speaking, I think most districts try to provide some type of FAPE plan, but this is not the same circumstance, because during a period of suspension, general ed students and special ed students who aren't suspended are in school. So this is a situation that is impacting every single student across the country, and certainly in our state, and here in Rochester, the schools are closed. So it's just different for everyone. We can proceed to the.
Great, thank you. So what obligation does a school district have to comply with the IEPs and 504 plans of students with disabilities during the current school closings?
So and can you move us to the next slide, Laura? So the guidance that we have gotten on this from New York State Ed is that the students continue to be entitled to a FAPE, free appropriate public education. It's always a challenge to determine what is considered appropriate under the law. It generally means that the student has to be making meaningful progress in light of all their circumstance. But in this case, the guidance that we've received has been that NYSED will allow school districts as much flexibility as federal and state law and regulation allow in determining how FAPE is to be determined. Pretty much from the parent attorney perspective, that means it's the same as it is any other time. When the schools are open or closed, it's the same basic situation, because they're limiting it to the flexibility that the law typically would allow anyway. Did you have a perspective on that, Yolanda?
Yeah, so first of all, my perspective is one that as I'm offering my perspective, I just want to qualify that I'm not necessarily offering the perspective of the Rochester City School District, but what districts in general may argue, because when we come back from the school closure, again, we're all going to be in the same boat, and everyone's going to be trying to figure this out together. And I think districts across the country are struggling to put together some sort of uniform response to questions such as this and what will happen in the analysis when we come back from school. And one of the things that I know from being in on conferences with the Council of Great City Schools is that some districts may argue that we aren't necessarily in a FAPE world because the FAPE is something that is provided during normal instruction, during the normal instructional delivery, and we're not in that world today. However, I'm not sure how those kinds of arguments will be received, when or if they're put to the test, what the outcomes will be. But I just wanted to say that there are those who would argue that that's not where we are right now.
And the parent attorneys, I'm sorry to interrupt.
Mm-hmm.
Parent attorneys are concerned because the current Secretary for Education for the U.S., Betsy DeVos, pushed through a provision in the CARES Act that allows her to make a plan for what changes that she would propose to Congress about altering IDEA during this time.
Mm-hmm.
IDEA is the Individuals with Disabilities Education Act, so we have concerns that she may be exempting school districts from providing services consistent with students' 504s and IEPs. That has not happened yet. Her plan was due by the end of last week. We haven't yet gotten any idea of what that looks like, but it would have to pass through Congress first. I do think that FAPE would have to be responsive to students that are not signing in when they're being provided the distance learning. That's something that we talk to parents about the importance of keeping their kids connected. And, you know, there's a lot of parent stress around being the teacher now. So it's not entirely clear what FAPE would look like upon return. Parent attorneys would advocate for the usual standard, that the student is making meaningful progress in light of all their circumstance.
Mm-hmm.
We're going to bring us back to ESY, extended school year, and compensatory ed later. We're going to delve into that a little later in the PowerPoint. Right.
So again, one of the potential tacks that districts might take could be that, if we aren't in a FAPE world, then these concepts wouldn't necessarily apply. The other might be that in spite of guidance, because the New York State Education Department guidance that's been put out on COVID-19 is exactly that, it's guidance. I think that a lot of district attorneys are somewhat aghast at guidance coming out that are linking, in very clear language, linking FAPE to the COVID-19 circumstances. And I think there may be a wave of folks, especially on the district defense side, who would take that non-FAPE tack and might also take the tack that SED or state guidance is exactly that, it's guidance, and that what really prevails is the law. And that just because a guidance is issued that links certain concepts together doesn't necessarily mean that that's what the law requires. This is just going to be a very interesting time for all of us that are involved in this work. So to me, it's fascinating. This is novel, and there's plenty of room for discussion.
Great, thank you. Our next question. Students were scheduled for their annual review and the meeting was canceled. Is the district obligated to hold that meeting? If yes, what if they are past the annual review date listed on their IEP?
This is the law that governs annual review from IDEA. It requires that an annual review be held annually within 365 days of the previous one. There's certain staff that's required in an annual review, and the expectation is that it will create a plan through the IEP for the student for the following year. But there is state and federal guidance that they can work with parents to make an appropriate accommodation. Can you move forward to the next slide, Laura?
Yes.
They're saying that they are granting flexibility to the districts as much as the federal and state law and reg allow. And then they expand upon that a little bit while saying that they would expect that during the emergency, districts would work with parents to reach something that's mutually agreeable if extensions, with agreeable extensions to establish timelines, right? The parent attorneys would fully expect that with that guidance, the district would work directly with the parent to meet the annual review deadline, the expectation. And I know that I had 15 annual reviews on my schedule in the next 2 weeks from the time that COVID closed the schools. The districts, we would fully expect that the districts, while those might have needed to be canceled, would be cognizant of the upcoming date and remain in compliance with those. There is additional guidance that allow them to do it through Zoom or through GoToMeeting or one of the other online platforms.
Mm-hmm. Yes, I agree with all of that. Certainly, again, as I said, the law is the law. It has not been changed. This has not been moved. So the timeline is still there, and districts are required to meet that timeline. But as Jane indicated, the indication is that districts will be given some flexibility. I know that a number of districts are using the ability to be able to agree with a parent to an extension of the annual review. If that timeline passed during the COVID-19 closure, then more than likely for districts that are taking that position or trying to utilize that aspect under the law, will be placing calls to parents, asking parents to provide a convenient date for them or a date that's mutually convenient for the district and the parent to reschedule the annual review on consent. Districts, for those that doesn't happen, districts will, just when it comes to regular data submissions and monitoring for timeliness of meetings, that will just be a hit that districts are going to take, on the compliance side.
And, forgive me, and there was additional guidance. We're specifically talking about annual review, but the other forms of CSE, the initial eligibility meetings, the program reviews, the reevaluation reviews also were being held to the same standard as annual review under the NYSED guidance. With regard to the second half of the question, it would be considered a violation if the district exceeded the 365-day limit if they got past their annual review date. It's something that would typically be addressed through due process if the family felt the need to do that. Often it's something that we delve into if there are other additional issues. It's not usually something that we would pursue due process on just that one violation, but it is certainly one that we would add into a pile of others.
Especially though, Jane, if the delay or the date fell during the closure time and before districts were up and running with trying to meet all of their responsibilities during the COVID-19 closure. I think if a matter were filed for due process on this issue alone, that certainly that flexibility the state education guidance is indicating would come into play. That if the districts, and I would think that if the district's efforts were reasonable in attempting to contact the family to schedule the annual review during the closure, and that those efforts were documented, and the responses were also documented, that then districts may in fact be given or provided some leniency with respect to not having met a timeline under those particular circumstances.
Okay, good.
Great. I actually have a couple of questions that popped in. One person is asking, how are evaluations being done under the current COVID situation?
Do you want me to answer that, Yolanda?
You can, Jane. You have experience with a variety of districts.
Right. So the guidance that we've been provided has been that if the evaluation can reasonably be done through the distance platforms, if you can do a speech language evaluation through Zoom, then you're expected to do it that way. But anything that would require that the school psychologist or, you know, the related service provider sit next to a student. How would you do a PT evaluation? That's more difficult. Then those are deemed to be suspended until such time as the schools would be able to actually do them in person. But if it's reasonable to do it, for example, say you thought you could do a speech language one, the parent was at one end with the child and the speech language therapist was at the other end of the distance learning platform, and that it could have a valid result, then the expectation is that it would move forward. That's the guidance we've gotten so far.
And I agree.
The other one, actually, there were a few that came in today when people registered and we weren't able to grab those questions. So one of them was asking that they had their annual review. Unfortunately, the district and the family agreed that the current placement wasn't appropriate, but they can't view any other placements, but also under tremendous pressure due to behavioral challenges, because those placements tend to fill up quickly, to place their child in something they haven't seen. So I didn't know, they're looking for, do you have any suggestions or ideas for the family?
Well, is it okay if I go, Yolanda?
Yeah, go ahead.
I've heard from at least one district that BOCES, at least one of the BOCES, is talking about virtual tours, that's what they're offering. So it's not the same. And I've often said that when a parent goes out to tour one of the outside programs, BOCES, a hillside program, any of those kinds of settings, they usually can tell us within about 15 minutes whether or not their child will be successful in that program. So it is different than being there. But if the point is to try and advance the CSE process to get closer to having a spot open up, there can be value in doing that. I would also want to add that they specifically put out guidance around mental health and the need for the districts to work with families to provide any kind of behavioral or mental health therapies that would be needed also through the online platform. We've had some conversation with Strong Behavioral Health, who's telling us that they've had a dramatic fall off in the number of people that are interacting with them during this time. So they're actually more readily available at this exact moment. People much smarter than me know about whether or not you can call the crisis intervention people. Apparently that is also an option if you're starting to move into a place where you have those concerns, and that is also something that the district can help you with. So I would check with my district to see if a virtual tour were available, and then determine for myself whether or not I was comfortable with that for the purpose of moving forward the process for getting the student placed there at some point in the future. What about you, Yolanda? Have you heard anything?
Yes. So I think what's happening is that, things are evolving almost daily. One of my experience has been, yes, that intakes are being done, but just based on a review of the student's paperwork. And again, not necessarily based on a face-to-face with the student or a physical tour of the school. It is challenging for families because even with a virtual tour scenario, ideally you're going to want to be able to tour the program in its normal state, where you can see how other students are behaving or interacting, and that you see active instruction going on. Arguably, we can't take parents on tours of individual homes, and an individual home setting doesn't necessarily replicate the school setting. For the most part, districts are trying to write IEPs as a result of the annual reviews for the time when schools reopen. So you kind of have to think about this, at least for now, in somewhat of a compartmentalized fashion, because as part of any contact that a district would likely have with a family during the closure, there's going to be a discussion about a continuity of learning plan and how the IEP might be adapted to be able to address that during the COVID closure. But the actual IEP is really being written for when schools return. And the plans for what's happening with a student is for when schools return.
Well, that presumes that you're talking about an annual review, Yolanda. I mean, many times when we're at annual review, we're also modifying the program as it's written on the IEP for the current academic year.
Well, so all I'm saying is that, again, this is all across the board with various districts. I do know that, and I can certainly speak for the Rochester City School District at this time, my understanding is that the special ed administration is writing IEPs for when schools reopen. Because if a student needs a special class, there's no way we're going to be able to provide a special class during closure.
But they would have an obligation to alter this year's IEP to reflect the need for additional supports if that's their partnership, right? I mean, if it's in order for the student to be able to delve into his educational experience, he first needs Rochester City or Rush Henrietta or Pittsburgh to align that student with some level of mental health in order for it to be successful. They still have that obligation, assuming FAPE is still the standard.
Yes, however, for many districts, that will be done under a continuity of learning plan and an IEP that's developed for that purpose. So a pseudo IEP, if you would, for the purpose of the COVID closure, but still addressing the IEP that would be in effect and fully implemented when schools return. So it's almost like a bifurcated review where the understanding is that districts are doing everything they can to support students with disabilities during the closure, but that the support that would occur after schools return might look different.
Okay.
Great, thank you. Also, I wanted to remind everyone too that you can always give us a call here at Starbridge. We're more than happy to work with families, talk about the process. I know I recently worked with a family where they did a virtual tour and they were able to also talk to the administrator of the program. That they found that to be helpful, and I have appreciated how districts have been extremely creative. We do have another question regarding annual reviews and IEPs. It says, are schools responsible to make new accommodations for kids with IEPs or 504s due to distant learning issues that aren't the norm?
Ooh, that's a good question.
Very good question.
What do you think, Yolanda?
Well, as I said, I think that, we certainly, and districts can't and shouldn't be ignoring the circumstances that we're in. And these circumstances that we're in create a whole new set of problems and challenges for students who are trying to learn from home. So to the extent that a student who's trying to access their learning platform from home and that the disability is interfering with their ability to do that, then that I would certainly expect to be part of the conversation for the students' support during their continuity of learning during the closure. That would be an expectation. Those novel issues or new challenges should be discussed with school staff when parents are contacted regarding their child's continuity of learning plan.
Right. And it's been in talking to parents in the last couple of weeks, I can tell you that while I would 100% say that the law would endorse the idea that as long as FAPE is the standard, whatever learning environment we've dropped this student into, we have to adjust to make it appropriate given their disabilities. That is just the only way an education makes any sense. If a student can't access it or if it makes them more disabled because we pushed on certain buttons. But I can report back in talking to families that has certainly not been happening. We've really struggled to get districts to deploy their special ed teachers and some of their special ed supports through those venues. And a lot of kids are simply being given access to Google Classrooms that do not have special ed support. So that appears to be what's actually happening. We would argue that in fact, it would be appropriate to open a CSE meeting for the purpose of having that discussion and making those modifications, especially if the closure, now that we know the closure is till the end of the year and potentially until the end of the summer and even into the fall.
Great, thank you. So our next question. They told us in our faculty meeting yesterday that we will not be passing students who don't participate in this fourth quarter, even if they pass the first 3 quarters. Instead, you would get an incomplete and have to finish over the summer or next year to get your course credit. Can they do that? What is the legal standard for determining that a student has passed a class?
And kudos to whoever gave us this question, because it's much more a regular ed one. It still pushes on the students with disabilities, but it's not really, Yolanda's in my area of expertise, but I did go and look it up because I was curious. And there's guidance from Commissioner Elia, who's now left us, but this year she put out guidance that specifically states that New York State and the region specifically do not take a position. They have established no policy relative to a student's course grades, and that they would fully expect that each district would establish its own grading policies. So in answering that question, I would encourage this faculty member to go see what the grading policies are for their own district. Do you think that when I read this question, my first thought was there's a lot of kids who are not signing in. They are not showing up in their Google classrooms and they're not doing the work. And I suspect this is a district's effort to try and it's the stick to get the kids to sign in so that they don't have to then repeat the course the following year. What do you think, Yolanda?
Yes, I mean, I would imagine that to be the case. I mean, we've specifically said that we don't want to name any particular districts or students or family circumstances in this presentation. So I would just encourage the person with this question to make sure, as Jane said, that you contact the administration of your district, but also take a look on their website and look at their grading policy. They should have one. And if they don't, I would certainly demand that the person be provided information as where they might be able to access it. Again, this is not an area that Jane and I delve in normally, but I have also heard that a number of districts during this fourth quarter, if the school has been closed for the entire quarter, will be providing students with a 65% passing grade, so that at a minimum, so that
for the third quarter, Yolanda?
I'm sorry?
Specifically for the third quarter, or are you talking about the fourth quarter?
I'm talking about the fourth quarter. The question was concerning the fourth quarter.
Yeah, it's the widest possible range of responses, and it's just school district by school district. You know, it 100% depends on who it is that's making the decisions within the district that are driving what teachers do. And apparently New York State is not interested in delving into that and establishing a standard, although maybe now they'll have to.
Yes, and I think also, you know, the policies that are coming out of this circumstance and the guidance is evolving every day. I would imagine that what I think a lot of districts are doing is just trying to catch up and keep up with the circumstances that prevail as time wears on. When this first started, and schools and everyone was being told that schools would be reopened or stay closed until April 15th, first, you know, April 1st, and then the 15th, you know, some of these questions might not have been as much of an issue at the time. But now that we are in closure, at least in this county for the rest of the school year, I think these are questions that districts are wrestling with even as we speak.
Right.
Great.
Because they have a FAPE obligation.
Great, thank you. Our next question. What legal action can be taken against a school whose refusal to provide needed 504 accommodations, special education services, have caused severe delay in a child's education?
So this touches on a lot of laws, you guys. So we're gonna try and be a little methodical about walking you through to the ultimate answer, which is, what is the legal mechanism? The initial question that an attorney would ask on that fact pattern would be, was child find followed? Child find is an obligation by every district to reach out into their community and identify students, whether they're a public school student, a private school student, a homeschooled student, and and determine whether or not, put them through the process to determine whether or not they qualify for special education supports and services and for 504 supports and services. There's a separate legal obligation under each of those laws. When we talk about 504, which we will again in just a minute, we're talking about the Rehabilitation Act of 1973, Section 504. And it is not specific to public schools. It can cover the widest range. And one of the obligations under 504 is this child find. For IDEA, it's an integrated part of the statute. Can you advance the slide? Did you have anything you wanted to say about that, Yolanda, or shall I just keep on with trying to do my little tutorial here?
Well, sure, I would just add that, really most, if not all of these questions are really directed to the current COVID-19 closure circumstances. And under these circumstances, and the law is the law, as Jane has pointed out, and the slide shows you, the law is not cued to COVID-19 closure. But I think that, certainly districts certainly have to make sure that safety is a priority, and that doesn't absolve them of the requirement to pay attention to what they should be doing to identify, locate, and evaluate students suspected of having a disability.
So would you argue that, in fact, just like when we were talking about annual review and reevaluation and all of that, that there needs to be some flexibility with regard to child find at this point?
Well, I'm not going to create policy as a result of this presentation. That is something that all of the experts have to put their heads together and develop. I say, look, if I'm looking at the law and this is what it states, then under the circumstances, while all due consideration needs to be given to the challenges that these circumstances prevent, it doesn't change the obligation. So I would say yes, districts are still obligated, but the expectation would be that there would be some flexibility, around things like timeliness and what have you, with regards to getting this done. And also evaluating, as we pointed out earlier. Part of this child find process is the evaluation process. And there are some evaluations just are not feasible.
That was my question.
Period.
Okay. So in order to be able to answer the question about the legal remedy, we first wanted to take a minute and just talk about the difference between 504 and IEP. A student with a 504, as I said, that's under the Rehabilitation Act of 1973. It is simply defined as a student who has a disability that requires accommodations or services in order for them to be on a level playing field with the regular ed kids. Can you move us forward, Laura? And then an IEP is a student with a disability that falls within the 13 classifications, where the disability is interfering with the student's educational performance and who needs specially designed instruction or special ed services or programs to meet the student's needs. That person would qualify for an IEP. Now, why would we care about which one the student gets? Literally anything that you can put in an IEP, you can also put in a 504. There is nothing under the law that bars you from providing any service that you could get in an IEP in a 504. But in school districts trying to figure out the answer to that question, which one are we supposed to get to which kid, basically what they've done is they've broken it down into, if the student is a student who simply has ADHD and is perfectly fine in a regular ed room, and really just needs somebody to come by periodically and refocus and redirect them or reteach them a piece of information, but they're able to basically pass the classes and function in a regular ed setting, that student would get a 504, because they're not they're, you know, they may very well be passing their classes. Their educational experience, their educational performance is not necessarily being impacted.
And Jane, you're using ADHD as just as an example of a disability in this context, because certainly there are other disabilities that could give rise to a 504.
100%. And like I said, it's not specific to the learning environment. There's many, many applications for Section 504 in the wider world with adults and everybody else. But with regard to, so let me see, let me see. So let's move on to what's the legal difference between the two of them. Can you move us on to the next slide? So there's no legal requirement for the structure of 504 plan, and there's no required timelines for implementation or review. A parent is not even a required member of a 504 committee. They can make, the school is allowed to make changes to a 504 without consulting the parent. So from the legal perspective,
however, and let me just add to that, however, would not be a tactic or strategy or policy that I think, you know, any district should endorse. There should always be every effort to collaborate with parents and to have parents participate in the process of developing an educational plan to support their child.
And I love that about you, Yolanda, because we have certainly seen this in the wider universe. An IEP has a lot more legal supports pushed around it. And actually the people at the Office of Civil Rights have imported a lot of the protections that are pushed around an IEP to be inclusive of 504. They find that there's crossover before those two. So we are able to make some legal arguments based on Office of Civil Rights guidance to give additional supports to those 504 kids. But it is just a basic fact that there's a lot more legal protections for an IEP. So that drives what legal mechanism we would use if a student, as in our original question, let me get back to it real quick here. The original question had asked what legal action can be taken against the school. So can we look at the next slide? With regard to 504, the mechanism for enforcement is the due process complaint procedures per an individual school policy. Oftentimes that will be driven by filing a complaint to the Office of Civil Rights. That's a mechanism that we can use to begin to address a student who was not being provided their supports under 504 or reasonably should have been given a 504 and was not. Then with regard to an IEP, a parent can choose mediation. And I can tell you all about mediation. If anyone's interested in that, just raise your hand and let me know. It is a step in due process that is not required, but can be quite effective in negotiating with the district. Or you can move on to the complaint, which would then result in an impartial hearing. And if the impartial hearing goes all the way to the end, there's a little trial for that. So yes, please.
Okay, so part of the impartial hearing process under with an IEP does require the district and the parent to sit down and try to resolve the complaint. And the mechanisms for resolution are a meeting either that occurs at the district or outside of the mediation process and forum, and that, you know, every effort is made to resolve it before you can actually the complaint can actually proceed. Also, as a part of that is that one of the options in terms of that required resolution period is a mediation. So again, you know, you can start with mediation, as Jane is indicating, or you can go do the due process route, but the due process route is going to reroute you back to either mediation or some other form of a resolution session or period before the complaint can proceed to hearing. I just wanted to add that.
And I would qualify that. So the law in no way requires that anyone do mediation. Mediation is a choice that can be made by a parent and a district. Neither have to participate in it. It's an opportunity to have a free flow of discussion around reaching a resolution without a lawsuit.
Right, but the resolution period.
Let me just finish, Yolanda, real quick. So partial hearing, once you file the formal complaint, one of the initial steps in an impartial hearing process is something called resolution session, which is meeting, right? It's a slightly different posture, but it's basically the same idea. So a lot of times when I'm talking to a family and they're like, when are we going to sue? We need to sue. Let's get busy and sue. I will often propose the idea that we take the intermediate step of mediation to see if we can reach a resolution without having to file complaints and start a lawsuit against a school district. Did you have something more to say about that, Yolanda?
No, just that, you know, if I didn't make myself clear, I apologize. The resolution period is required, but mediation is an option as a parcel of that resolution.
Gotcha. And then the next slide, Laura, is just, it talks about, the only reason we put this in here was we just wanted to make the point that when you're doing a due process complaint, you are strictly limited to issues that were related to the special education process. You're upset about a lot of things by the time we get to this place, and they will want to put in a lot of issues that are not specifically the result of child find and then the special ed initial eligibility process, and then the development of an IEP, and then the inability of a school to meet those needs. The due process complaint and the impartial hearing are strictly limited to that stuff. It's not a venue to vent all of parents' issues or complaints. So we just put that in there just to qualify the reasons why a due process complaint might be filed.
Great, thank you. Okay, our next question. In this era of online learning, have you seen an increase in cyberbullying? What can families and schools do about that?
Well, interestingly, the New York State Education Department came out with guidance in among all of the COVID releases, press releases that they've issued that's specifically on this issue. They specifically highlight the fact that Section 504 and Title VI have separate mechanisms by which you can pursue, you can force the school district to address what would appear to be a bullying or a cyberbullying issue. I expect they anticipated the same issue that the questioner of the person that gave us this question, they anticipated that as well. So they've given us some guidance around the importance of invoking the Section 504. And when we say that, what we mean is if a student is being cyberbullied specifically related to their disability, or their race, or their color, or their national origin. The race, color, and national origin are more Title VI, but there is legal mechanisms by which you can pursue the school district around those issues under 504 and Title VI. I would also want to remind everybody that school disciplinary actions are also a possibility. The district code of conduct often will drive the right, and this has been supported by the courts, of the school district to suspend a student who has taken some action outside of school that is having an impact on school. And that can include things like cyberbullying. So that's not really helpful to us right now because nobody's in school, but that's another mechanism that can often be used. A student, a family would be able to file a DASA report. DASA stands for Dignity for All Students Act. And the DASA report doesn't necessarily empower a family to sue, but it documents and triggers an investigation on behalf of the family if there's been cyberbullying. And there'd be no reason why a district couldn't do some investigation remotely around those issues. They're often forced to anyway. So apparently this is being anticipated. I haven't gotten a lot. I take that back. Just today, I got a call from a student who has really struggled to stay connected to school, and she had her life threatened through the internet while she was doing distance learning by another student. So they called the police. So it is happening. I wouldn't say that I've seen a dramatic increase in it, but I might just not be talking to the right people. How about you, Yolanda?
Yeah, I think I've heard of maybe one incident in comparison to the numbers that we might hear of when school is in session. I think it's important from a district's perspective, and I would really like the audience to understand there's a very subtle nuance here when it comes to this issue, and that has to do with what's going on at school and how, when, where, or if the behavior is having an impact in school. So if you were just to go back to the non-school closure context, if two students are, or if your child is having an issue with another child on the internet, and say one child is from Greece schools and the other one is from the Rochester City School District, and it's really an issue that is occurring outside of the school context, then school districts may not necessarily be responsible for that, for those behaviors or for that conduct, or required to conduct an investigation. So in the slide, and I think we're on the harassment cyberbullying slide with the school disciplinary actions, the key words for me as a district attorney there are the words that discuss participation in or benefit from the services, activities, or opportunities offered by a school. And in the DASA paragraph, the fact that the action or activity occurs on school property or at a school function, or even if it occurs, there are provisions in the law that say even if it occurs outside of school property, but it has an impact within the school and on school property, such as, say, something that might lead to, escalate into a fight on school grounds that was the result of back and forth cyberbullying that led up to that fight on school grounds, then the district would have a responsibility there.
Okay.
Great, thank you. I'm just checking, I think we might have a question. Hold on. Oh, actually, and one person is asking, what if it happened during a Zoom learning session?
Fairport had that come up. That during a Google Classroom, inappropriate materials were put up for all to see, and the district was required to go in and address that. And my understanding is that a staff member was suspended as a result.
Yeah, I would agree.
Great, thank you. Our next question, how will ESY or extended school year services be determined after such a long period of time of being out of school? What happens if regression is found, but there is no summer school?
So this question brings us back to what happens when we go back. Schools are closed. There's a lot we have no control over at the moment, but at some point, the big yellow bus is going to show up at people's houses and the kids are going to return. And under the FAPE standard, they would be required, the school districts would be required to provide services to the first one we're going to talk about is extended school year, right? So if schools reopen, let's say that magically happens July 1st, and in order for the student to be ready to begin the next grade the following year, they're going to need some level of support through the summer, just to be held steady. It's not supposed to advance a student's education. It's just supposed to hold them, prevent them from having further regression so they're not horribly behind the 8 ball when schools reopen and all the other kids have remembered a whole lot more or have retained a whole lot more than they did from their previous reading lessons and math lessons. The legal standard for that is regression testing. And to do regression testing, there's every imaginable way to do it, but essentially what schools routinely will do is they'll test a student on a piece of new novel information before a school break, then they'll check back at the end of the break and see if the student retained it, and then they'll determine how long it took that student to recoup it. And based on that data, the information that's gathered, a decision will be made by the CSE committee about whether or not that student's going to require some school services during the summer in order for them to be ready for the following fall. Now, that would push pretty hard on this whole situation. We really know that a lot of our students with disabilities are not getting the kind of content that would allow them to be ready for next fall. But regression testing is limited in its scope to only providing enough service during the summer. It's not supposed to overcome a deficit, right? And then the second half of that question is, if regression testing is found and there's no summer school, then let me see. Then can you move us on? You see there's the law related to the determination of ESY. Then we would have to talk about what's called compensatory educational services. If a student was entitled, for example, to extended school year, and the summer school never happened, it just never opened, they kept the schools closed through the summer, then we would be having a discussion with the CSE committee about providing the student compensatory services to make up for what they should have gotten, but they didn't get. And that's a much bigger pot of services. For example, if a student right now is entitled to speech 3 times a week and the district hasn't been able to access, their speech language therapist hasn't been able to Zoom with the student and provide the teletherapies and manage it that way, then the student would be entitled to compensatory services at the level that the IEP would have required. And there's the law with respect to compensatory educational services. So we would be talking about ESY, but we might very well also be talking about a lot of services that got missed. Now, the one qualifier on that, once again, we don't know what's going to happen with Betsy DeVos. She may exempt the schools from having to make up supports and services that were legitimately and legally required by the IEP for the period of the closures, and we have a lot of fear that she might damage the IDEA even past that. What do you think, Yolanda?
Well, this is a really loaded issue. I think on the ESY side, there are going to be challenges with respect to the collection of data, because typically a regression analysis, as Jane indicated, would take a look at what happened before a regularly scheduled break and what typically happens with the student after the break. In this case, we have a much longer extended period of time that the student isn't getting the instruction in the normal fashion. Exactly how districts are going to handle this, it's really hard to say at this point. I think that districts have been really struggling with just getting a continuity of learning plan up and running, what happens with students with disabilities during the delivery of a continuity of learning plan, actually putting the components into place for implementing those plans and providing the supports to the extent practicable for students with disabilities. Now we're moving into, the fourth quarter questions with grades and the like, and I think districts are really struggling to keep up and figure that part out. And then once the fourth quarter is over, as it's approaching its end, the summer school questions are going to be addressed. So I really think districts are sort of taking this in stages because it's really hard to address everything at once. But certainly there are some students, by virtue of the disability, by virtue of previous data collections, that indicate the need for ESY. And I do know that for some categories of students, and this is certainly on a student-by-student basis, ESY is a given that the student is going to need or require ESY. And so for those students, during IEP meetings that are occurring during the COVID-19 closure, they will still be checked off as needing and requiring ESY. And whatever that's going to mean, depending on whether or not schools can come back into session, I would imagine that if there is no summer school, then we might be looking, or districts might be looking at having to deliver ESY services again through a remote platform. I don't know. I honestly, none of us really know at this point exactly what that's going to look like. However, I would beg to differ with Jane, and we enjoy sparring with each other. But I did start off the session saying that districts are certainly taking a look, and this isn't just local districts; it's across the country, are looking at the whole concept of FAPE in the first place during the COVID-19 closure, and also the fact that compensatory education typically implies that the district was at fault for something or didn't provide something that it otherwise should have. And there's certainly a lot of room for argument, if you will, as to whether or not what fault the districts have for this public emergency and COVID-19 closure. So that's another level of discussion or debate, if you will, that can occur around the compensatory, the question about whether compensatory education is due. And yet a third level really boils down to the standard that ought to be applied to a compensatory education review. And I think that districts and jurisdictions are vary with this, and it really depends on what the case law, the prevailing case law is in the jurisdiction. But there has been some discussion, I know, with across the nation as to getting the National Department of Education to identify a uniform standard for how compensatory education is determined as to whether or not it's owed. One of the arguments that Jane and I have had, is that, well, is compensatory education really a one-for-one? So that if a student was required to have, 5 hours of speech during a particular week, and through some fault of the district that was not provided, that when we're having the compensatory education discussion, that the student should automatically have 5 hours of speech put back on their program or into their schedule. There are a number of problems or issues with that. One simply being what the student might even be able to handle. Can a student now handle 10 hours of speech, the initial 5 and the additional 5? What can a student reasonably handle? What can actually fit into a student's schedule? What are parents willing or ready to support? And then another layer to that argument is, well, is it really a one-for-one? Or is it really about the individual student? So that if a student had a particular speech goal, and I'll continue to use speech as the example, if a student had a particular speech goal and that goal has been met, or the student has reached maximum potential in achieving that goal, is our 5 additional hours to compensate for the 5 missing hours actually required? Or should it be 1 or 2 or 3 hours because the student is just about there? Or if the student has met goal or has reached maximum potential, then maybe no compensatory education services are due. So I think this is a very, very weighty issue, and the outcome is going to really depend on the individual student, and as well as what's going to happen with any type of a unified standard coming out of COVID-19 closures.
Right, and as the parent attorney, and as you can imagine, our parents are very frustrated given the unfairness of all of this, that so much is getting pushed back on them. So the theory that in fact a full CSE committee made a determination in order for a student to reasonably progress on a goal was going to require 10 speech language sessions, and for the district to come back and say, well, we're just going to give 4 and then we'll see where we're at the end of 4, is a source of great frustration. And as a parent attorney, I would very much push on the issue of the parent needs to be a very important part of the conversation that results in compensatory education, because as you say, it does need to serve them and their student. But right now, parents are being given the obligation and responsibility to be the guy the lady I was just talking to today, the CSE chair, was saying, we're going to put up some things that mom could do for her child around speech language. And given that this isn't fair to the schools and it's not fair to the families, that's really not fair. So
I think that's
you said we need to be able to spar back and forth about this, but there's a strong legal argument to be made that in fact a student, that when it comes to compensatory educational services, the parents need to have a strong voice in what the outcome of that would be.
Absolutely. I would 100% agree that a compensatory education review, requires the collaboration and the participation of the parent, and it should be done in a CSE format.
Great, thank you. We do have a question, and they're asking if there are any examples of long pauses of education services and if there was any guidance, such as a natural disaster. Also, if a student is in their final year, can compensatory education services be provided from an outside agency?
Okay, so this is our last slide?
Hmm.
Because
Uh,
those
this
questions
is
are
a
on our last
question
slide.
that came in, maybe?
It's a question that just came in. I'm so sorry. Yes. Do you want me to
Okay.
read it again?
Yes.
Okay, sure, but it sounds similar to one that we're doing next.
Oh, does
So
it?
please.
Okay. Yep. So I can move it to the next.
Why don't we do this? Why don't we answer the compensatory ed, since we just finished speaking about that? Why don't we answer the second part of that question as it
Well,
relates
let's
to
read through the question, because the reason why this question came last was because Yolanda and I, in discussing it, felt like it tied together a whole lot of stuff.
Okay.
And the person who wrote it, boy, they had time on their because it covers such a broad range of information, and it sounds kind of similar to the question that's come in.
Sure,
So
sure. So let me go
one
ahead.
and then come back to that question.
Perfect. Let me read that. Will districts be graduating all students with disabilities who have or will turn 21 by June 2020? Also, will ESY or extended school year be available to students? Does this include students that are alternatively assessed? If the governor determines districts will not be going back to school this year, will these students automatically receive extended school year if they were exiting in June? If not, what are the alternatives for families? Would compensatory services be a possibility? If compensatory services are determined, who can provide those services? Can a school district contract with a community agency to provide those services if they are not available through the district? Oops, I apologize for that. Let me go back.
It's okay.
Okay.
So it's a lot, right? So the law would say that a district is required to continue to provide an education to a student until such time as they achieve a diploma, either local or Regents, or through the year in which they turn 21. So if you turn 21 on September 15th, if you turn 21 before, as the school year is beginning, then they would be required to continue to provide you the education to the end of that school year. Now, the issue related to the provision of ESY, in a typical year, the expectation is that the student is graduating in June and so would not be eligible for extended school year unless it was determined by the CSE. In order for there to be a FAPE, the student needed to remain, because the idea is they will have finished their school year and it will be done, right? But in this case, it may be that while ESY wouldn't be a possibility for a student that had fully graduated, that compensatory educational services would be, in light of the fact that they did not have access to their education during the time that we're doing social distancing. Especially if we're talking about a student that's alternatively assessed. I don't know how many of you are familiar with alternative assessment. Every school district in New York State is capped at 2% of their students that they can designate as alternatively assessed. And the implication is, if the student lacks the intellectual capacity to engage in a Regents Track diploma or a local diploma, that they can be provided these alternative assessments that will allow them to not meet the regular state standards for reading, writing, and math. So in those situations, for those that are being alternatively assessed, the expectation is you finish out through June of your year in which you turn 21 and you're finished, right? But we would argue for compensatory ed for those kids in a situation like this if it appeared that in fact FAPE hadn't been achieved and that it was necessary to give them additional services in order for them to get the same benefit as they would have if they had been able to attend school until they're 21. A district can contract with anybody they want to provide services, but they would be required to do it if it wasn't available through the district. But most things that are on an IEP are something that's available within the community. Did you have anything to add, Yolanda?
No, because I would still stand, I would stand on, you know, just with respect to the compensatory education piece alone, I would just stand on what I said earlier. But here, I think in this question, the key distinction for me is that age 21 and possibly also NYSED, putting aside compensatory education, which again, I would repeat pretty much what I said earlier.
Right.
So I don't disagree with anything that Jane has said, and if she and I were on opposite sides of the argument around any particular student concerning this, I haven't found anything that I would necessarily disagree with. Yeah, no, Jane, I concur with everything that you said here.
Right. But I would fully expect to have to like make the legal arguments for the purposes of compensatory ed in a situation like this, that it was necessary for a free appropriate public education.
Understood.
I did have a question come in. It said, what if the student is working towards a diploma or a credential and did not have access to their program?
That would be a classic example of compensatory ed.
Question again?
What if the student was working towards a diploma or their credential, but they didn't have access to their program?
Right.
I think not having access to their program, for me, that's a circumstantial, that part of the analysis on the district side of things would be what the circumstances around not having access to the program were. But I certainly, on a baseline level, the fact that a student didn't have access to a program when we would expect that student to have access to a program and a district to facilitate access to that program, you know, there's the rub, right? If it's the district's, if somehow the district is at fault for not being able to facilitate that access, then that's one issue. If there were other circumstances, that none that can come to my head, you know, right now, that might mitigate the district's circumstances or liability in this scenario, certainly as a district attorney, I would be trying to expose any and all of those mitigating circumstances.
And I would, so we've been advising parents to document daily, because they know what's in their student's IEP, document what they got and what they didn't get. Just keep a log, why wouldn't you? And that will give you some guidance later on when we're trying to assess what happened and what didn't happen. I would fully expect the teachers and the school districts are doing the same. They're documenting that they believe that they provided some level of speech language support to a student that requires that. And then it becomes that conversation. I think it gets tougher because you referenced getting a credential like the CDOS credential. And in that case, the student needs to have work experience equaling a certain number of hours. So that's a different problem, because we can't send that student out into the community to fulfill the requirement that's CDOS credential, that CDOS credential requirement. So then what would you expect the school district to have to provide in a situation like that, Yolanda?
I'm sorry, Jane, say that again.
So in a case where in order to be able to achieve their CDOS credential, they required work experience in the community, and they can't fulfill that requirement without the work experience, the number of hours necessary for that work experience. But right now during COVID, they can't.
Because the
student was turning 21, and now we were coming into the time when we could now be out back in the community. Would the districts support the idea that that student, rather than necessarily be graduated, would be given the supports necessary by the district to meet the needs of that CDOS credential?
So I can't speculate on what the Rochester City School District would do.
Right.
You know, I think, as I said, every case is an individual one. But certainly, if that's the credential or the work experience is something that's required to satisfy the credential, I would think, look, this is about students. This is about kids being able to go out into the world and to be able to survive. and to have some meaningful skill that will help them do that. I would imagine that any district would look at each case and try to figure out a workaround so that the student can have those needs met, those obligations met, as well as be able to satisfy their graduation requirements.
Thank you.
Mm-hmm.
Great, thank you. We do have a few questions that have popped in during your presentation, as well as I'm encouraging anyone, this is your time too, to feel free to bring up your chat box and type in any questions that you'd like to ask. So the first question is, what are parents or families' rights when the student has a 504, an IEP, and is having behaviors in a charter school? Can the charter school simply encourage the family to take the student out of the school without doing any type of either data collection about the behaviors like an FBA?
Okay, so the interaction between the district and the charter school is super messy legally, you guys. It's very complex. And the courts have not done a lot to clean that up. But right now, the way that things stand, if I have a student who's having a behavioral issue and they're in a charter school, the charter school would have an obligation to, they're only required by law to maintain the parts of the curriculum that would include regular ed kids. So they would have to have regular ed classes, regular ed with consultant teacher, integrated co-taught classes, right? If the district and let me see, if the parent is at a place where they believe that the student is going to need more support than could be provided through any of those settings, they would need to trigger the process, the special ed process, which is the exclusive domain of the host district. So the charter school would be collecting the data and getting together the information and providing the evaluations. The home district would be using their special ed department in order to gather that information, hold the initial eligibility determination or the 504, and make a plan if the student is found eligible that could be meaningful in the charter school setting. If the student is going to require more supports than on those three stops on the continuum, then the charter schools are not legally required to provide, for example, an 811 class. They can be pushed to provide certain behavioral supports through an IEP or a 504 if FAPE is met by that IEP. But it gets very challenging when we have students that have behavioral needs, they're in a charter school, they need more supports, the district is saying, not our problem, which we've certainly seen happen, or they're refusing to provide one-to-one support to the charter school. The charter school can provide one-to-one support. They are not legally obligated to do it. Unless the only setting in which the student, if it's the student is in an integrated co-taught setting and a one-to-one would be enough, we could make a legal argument that a one-to-one would be necessary. But typically those services are provided through the IEP, and that would mean that it would be the obligation of the host district to provide. So there's a lot of everybody wanting to cross their arms and say, not me, when there's interaction between the district special ed and the charter school administration, and the families often get caught in the middle of all this. Routinely, over all the time that we've seen charter schools, there's been a dampening effect around the admission of students with disabilities. Not that I'm throwing, cold water on charter schools, but study after study has shown that they tend to discourage families of students with disabilities, and they will often encourage them to enroll in the regular ed district if it doesn't seem like, if it seems like the challenges are exceeding the capacity of the charter school to meet the students' needs.
Yes, so, and I agree with everything Jane has said. I think on a district side, which is the lead educational agency, the district responsible for holding the CESE meetings and putting together the IEP, the district certainly would be obligated to provide whatever services that the child needs, but not necessarily at the charter school. The district's position might be, well, okay, this student requires XYZ services and supports. The charter school doesn't have them, isn't obligated to provide them, but we provide them. And so therefore, you know, mom, dad, you're welcome to enroll your child in the school district, which is the lead educational agency for your child, and access those services there.
Right, and then it's a parent choice, right? They can, if the district has created a legal IEP that achieves FAPE and would meet the student's needs, now it's incumbent upon the parent to decide, I'm going to forego those services and remain in the charter school, or I'm going to take advantage of that IEP and move over into a school district, the regular district setting.
Correct.
Great, thank you. There's a couple of different questions. I'm going to group them together because they're very similar. If this child has an IEP, is the district required to provide a special education teacher on Zoom? What if a child also has a one-to-one? And how does that work?
That's a great question. Right now, the guidance we're getting from New York State Education Department and U.S. Department of Education has been that, in fact, the IEP services are to be provided to the extent that they reasonably can, but they do specifically give some, they recognize in their guidance that there may be some services that it is not practicable to be able to accomplish through distance learning. So the idea that, yeah, I mean, we can't provide an 811. Right, but as you say, the 811 comes with a special ed teacher associated with it. The question becomes, is the student entitled to that number of hours of access to the special ed teacher during the time that they are out of school? And some percentage of that is getting answered just in the practical form of, okay, that's 6 hours a day, and the parents don't really actually want a special ed teacher on the computer for 6 hours a day. So we're all having to learn some and push over a little bit in answering that question. The parent attorney answer to it is yes, they absolutely need to provide the supports and services that are on the IEP, but the practical implications of doing that would challenge a parent. So we're having to have these conversations sort of on the fly and trying to figure it out as we go. I have one district that has a boy who's got very significant, actually it's Rochester City School District, Yolanda, who had a lot of challenges at school, and they are providing him access to a special ed teacher an hour and a half a day, 3 days a week. And he seems to be able to handle that. So that's a reasonable accommodation to make around what's going on. Mm-hmm.
Yes, and so I agree with everything Jane said. I would probably just add a couple of things. There are some nuances here that I think would need to be explored on a case-by-case basis again. One being the purpose of the special education teacher. If the purpose, because of the student's needs, was because the student requires specially designed instruction, then I would certainly expect that at a minimum, to the extent practicable under the COVID-19 circumstances, that any material that the student is getting, that there have been some modifications or efforts to try to modify the material or to instruct the student somewhat differently than the gen ed student might be instructed on the same material. And so it really boils down to the individual need of the student, what the purpose of the program, of the support, of the accommodation was. Taking that into the one-to-one realm then, one would have to ask the question, is for this particular student, was a one-to-one required because the child is easily distracted by large peer groups, or being in a large peer group, or the typical classroom setting, that the breakdowns or the meltdowns really have to do with that social atmosphere? Then one might argue that, well, if this is a child in a home with only 1 or 2 children in the home, then the same potential chaotic social environment isn't existent in the home to the same extent that it might be in the classroom setting. So I just really think it boils down to specific circumstances for specific children.
But to the parents out there, I would encourage all of you, because the the truth is that there is an IEP. It's written to meet the student's FAPE needs. There's a strong argument to be made that, in fact, you're entitled to have those supports and services in place to the extent that it's necessary. And I understand that as a parent, it's very frustrating to have the district make the kinds of legal arguments around, okay, a one-to-one isn't actually going to do your child any good when the IEP clearly says they're entitled to that under the law. So I would urge every parent to request a program review, to have the discussion directly with the special ed people, so that there's the decisions that are made are one that the parents can live with. Right.
But there's also the public health emergency circumstance. I mean, a one-to-one is not going to be dispatched to the home under these circumstances.
But at the end of the day, for the district to just decide that without having a conversation with the parent is not consistent with the guidance they've given about the need to remain in compliance with IEPs and 504s during a closure.
Certainly. So then the discussion with the parent would be that when school returns, does your child continue to need the support of the one-to-one? While we're out of school during the COVID-19 closure, how is the issue or the need that gave rise to the one-to-one impacting the student during the COVID-19 closure? That's a separate discussion.
But right now, the parents are in the awful position of having to figure out how they're going to navigate their child's education with them being the teacher. And if there's no support being provided to them by the school district in the form of some of the things that are being detailed on the IEP, that is a discussion that reasonably should be had by a CSE in order to make the decisions that would allow the student to, if at the very least, not interrupt the parent-student relationship that's under a lot of pressure right now. So I urge parents to pursue a program review for the purpose of having that conversation with the people that have the power to provide supports and services that you may believe are actually necessary during these times of school closure. Because it's really a closing, but schools are actually open for the purpose of instruction. They're just very limited in what they're capable of doing right now.
And I would hope that conversation would be occurring around, through the contact that schools and CSE staff are making to parents to discuss how the student is accessing the continuity of learning platform. I would expect the conversation to be happening now.
Well, that would be great. It hasn't been my experience.
Thank you very much. That was one of our last questions. I wanted to share with everyone today, we have, as part of this PowerPoint, Yolanda's information and her direct contact. And thank you so much, Yolanda, for joining us today.
My pleasure.
Jane Gabriele as well. Here is her direct contact information and her email. Jane, thank you so much for joining us today.
My pleasure.
And thank you so much, both Jane and Yolanda. It's been a pleasure. You bring wonderful perspectives to everyone who is able to listen, for everyone to remember. We're getting a lot of great comments saying, thank you so much, ladies. This was wonderful and very helpful. There will be a link to a SurveyMonkey tomorrow. Please just take a moment and fill that out. Again, remember, here at Starbridge, we're here to answer your questions. And I also thank you for the Special Education Task Force for helping to make this possible. So everyone have a wonderful evening, and thank you so much, and good night.
Thanks everybody for joining us. Good night.